Well, good evening and thank you very much for coming. At the 103rd session of the International Labour Conference in 2014, a complaint was filed against the government of Qatar relating to the violation of Convention number 29 on forced labour and Convention 81 on labour inspection. This complaint contained the threat of a commission of inquiry into Qatar for not complying with conventions that it had ratified. And this is a commission of inquiry is actually the ILO's highest level investigative procedure. Such commissions, in fact, are rare, and there have only been 11 conducted since the ILO was founded almost 100 years ago. So it is a very serious threat that is being held over the head of the Qatari government at the moment. In March 2016, the ILO gave Qatar 1 year to reform the kafala system and its labour laws before it would take a decision on the launch of an official commission of inquiry. In its report to the ILO on the 20th of February 2017, the government of Qatar provided details of its legislative reform and responses to the ILO delegation's concerns. I'm going to cover the report that the Qatar government gave to the ILO and make some comments on some of the issues. I cannot cover all of them, but happy to for you to raise any issues that I haven't covered during the discussion time. I should take almost an hour if I can indulge your patience. Well, to get right into it, the report detailed the legislative developments, which included Law 21 of 2015, as Fatih has just mentioned. And in that law, it is argued that it constitutes the abolition of the kafala system, whereby employment contracts now regulate the labour relationships, no longer a system of sponsorship. Also, that employees can change employers at the end of the completion of the contract duration, or 5 years if it is an indeterminate duration, without an NOC. An NOC is a non-objection certificate, meaning without the permission of their employer, which was the case under the kafala system. And lastly, that employees can apply directly to the government for an exit visa without advising the employer. The law number 1 of January 2017 actually repealed Article 7 about the employees going directly to the government. They changed that with law number 1 of 2017 and removing the obligation to notify the government of an exit and requiring only the notification to the employer. Now, there was a lot of fuss about this particular piece of legislation, a lot of criticism saying that it was a backtracking by the government and that now it is basically back to the same exit visa system with the requirement of the permission of the employer. Another argument, however, that I have not seen presented was that I always thought that it was a rather inefficient way to go about it for all employees, for example, to contact the government and not their employer if they were going to leave the country, which then meant that the government had to contact every employer for every employee who was going to leave the country. So a bureaucratic nightmare. So it made sense to me, administratively, for them to change that and simply require that the individual contacts their employer. I'll come to that again later on. The third legislative development was the notification of approval of a new law for domestic workers, which was notified on the 8th of February 2017. It has not been introduced yet. And fourthly, amendments to the labour law that established judicial committees for workers' dispute resolutions. I'm going to begin with just a very brief overview of the issues with the least problematic reforms, although you may disagree with them. Firstly, the notification of the approval of a new law on domestic workers. This is a very welcome and promising initiative. We have yet to see the legislation itself. But the report by the government said that it's covering age limits, which will be from 21 to 60 years of age, 10 hours maximum per day with rests included, 1 full day off per week, continuous day, provision of food and decent accommodation, medical care and decent treatment, annual holidays with air tickets, end of service bonus, provisions for dispute settlement and penalties for employers that violate those provisions. And they argued that the law will be in line with the ILO's Domestic Workers Convention. So this is a very new and very promising development. The second issue is the preparation of a national strategy for labour inspection. Now, this is a very important one to the government because part of the complaint to the ILO was with regard to labour inspection. Note that it's only a preparation and it has not been introduced yet, but it's going to be developed in collaboration with the ILO to increase interpreters and accompanying inspectors, national occupational health and safety plan, the auditing of living conditions, work environment and recruitment practices, training of companies on welfare standards, a hotline for worker complaints and a worker satisfaction survey. On occupational health and safety, an MOU has been developed between the Supreme Committee for Delivery and Legacy and the Building Woodworkers International Union for the World Cup for occupational health and safety and work accommodation inspections, as well as training on welfare standards. Fourthly, on communications program, a program between the Ministry of Administrative Development, Labour and Social Affairs and the Ministry of Transport and Communications. Here the aim is to include 1.5 million workers, to inaugurate 1,500 halls equipped with information technology and communications, to provide 15,000 computers at a cost of about 55 million reals, and internet access at accommodation sites with training and awareness raising regarding complaints mechanisms. And fifthly, the issue of passports. The government increased the fines for the withholding of workers' passports to 25,000 reals. I would have thought a good money spinner. The report listed 232 lawsuits in 2016 with regard to breaches of the law on passport confiscation. Fines were in fact imposed on 48 employers. 168 were withheld due to false notification or an amicable settlement with the employer. One of the things which was very much emphasised is that employers are required to provide lockable storage facilities in the accommodation sites to enable workers to have their passports and keep them safe. It is a remedy that we we proposed in the Qatar Foundation standards back in 2013. One of the issues here, of course, is that many employers argue that they are only holding the passports for safekeeping, and many of the employees will also say the same thing. We've never been quite sure in interviews on this issue whether that was coercive or genuine. Nonetheless, there is a law against it, and where employers are confiscating passports against the wishes of the employees, it's an offence. Now I'm going to deal with the more problematic issues as I see them. These are my humble observations, and I'm very happy to be corrected on any of these during the discussion. To begin with, the procedures for changing employers. The government has argued that this is to be at the end of the contract period, and if indeterminate, at the end of 5 years' service, or indeed if an employee has already served 5 years, even on shorter term contracts, they are eligible to change employers without permission of their employer. The government states, workers have acquired the full right to change employers. This right is exercised immediately without being dependent on an employer and after having completed the notification procedure, which is 30 days or 60 days if employed for more than 5 years. However, at the very same time, changing employers requires, and I quote, a certificate which attests to the amicable end of the contract relationship with the employer. Well, I'm sorry, but this issue seems to me to raise the question as to whether this certificate is any different from the previous requirement of approval from the sponsor, and where the employer can in fact object. They provided some statistics. In 2016, prior to the implementation of the new law, there were 2,228 transfers of sponsorship approved in 2016. This included 1,144 transfers without employer's agreement. Now, I'm assuming that a number of these, although we don't have the data for this yet, but we can assume that at least some of these were the regularisation of irregular workers in the country, which we knew was occurring at that time. In the 2 months following the implementation of the law on the 13th, which came into force on the 13th of December 2016, there were 5,196 transfers to new employers. But there were no statistics on whether or how many employees were unable or denied the right to transfer, or where a letter was refused from the employer, or whether a letter did not certify an amicable end to the employment relationship. The report did not make clear also who were able to change jobs. Further, while the right has been granted, the report neglects to detail the procedures, which we know can take months. From the migrantrights.org report on this, they pointed out that to change employers, a job offer or a contract from the new employer must be submitted to the current employer to inform them about the intention to change jobs. The current employer, in practice, must still provide a no objection letter to the new employer. The form provided by the ministry is in Arabic, so that workers who cannot read Arabic must use typing centres that will complete the form and send it to their employers at a cost of about 30 to 50 riyals. Further, a police clearance must be obtained from the embassy of the worker's country, attested by the Qatar Ministry of Foreign Affairs. and this must be submitted to the Criminal Evidences and Information Department to get a security clearance along with attested educational certificates. Copies of the company registration of the present and new employer is required, medical test and biometrical data, copies of the residency permit and the passport. Now, this is despite the fact that the worker has already completed all of these procedures originally when coming to the country. And could be argued that these requirements make the transfer out of reach for many low-skilled and low-income workers. So that's part of the main problem in the transfers. Freedom to leave the country. It's argued by the government that an individual simply has to notify their employer according to the employment contract, and particularly for holidays and emergencies, which may already be arranged, not emergencies, but the holidays. Therefore, it is argued, and I quote, leaving the country has become an intrinsic right which is not dependent on prior authorisation. Thus, instead of an exit visa, the employer issues a travel notification. In other words, the employee notifies the employer rather than asks permission of the employer to leave the country. I have here two certificates. I'm sorry, I tried to put this on the PowerPoint, but my technical skills were just not good enough, so I'm just going to have to hold them up. This is an exit visa that I was given back in 2015, and what you can notice here is that is in fact issued by the Ministry of Interior, and you can see the logo of the Ministry of Interior on the exit visa. Since December, if I'm getting an exit visa, it comes like this, no longer with the Ministry of Interior's logo on it, but simply comes from the Qatar Foundation, my employer. Okay, so this is called a notification of a travel notification. Oh, I think I've gone too far. Now, presumably, with the new system, an employer will be required to notify the Ministry of Interior that an employee is leaving the country, particularly if the person is going through the e-gate at the airport. If that's to be used. And of course now everybody has access to the e-gates at the airport. If the ministry does not receive notification, will an employee be refused an exit at passport control or at the airport or through the e-gate? Presumably yes, because passport control will not know if there is an employer objection to the employee exiting the country. Again, I'm sorry, but as I see it, the new law still requires approval from the employer to leave the country and can object. However, if the employer objects, now the worker can bring the case to a special grievance committee. That committee is comprised of two representatives from the Ministry of Interior, one from the Ministry of Administrative Development, Labour and Social Affairs, and the other from the National Human Rights Committee. The statistics provided by the report show that in the 2 months after the implementation of the new law, there was 109,804 departures for holidays and any other purpose. That constituted 59.5%. 74,000 odd final departures, which was about 40%. And 761 cases went to the grievances committee, where there were objections to their exit. Of those 761 cases, 485 the committee found in favour of the worker. And I heard things like they would call the kafil of a company and say, why are you objecting? And they knew nothing about it. Quite often it was simply a lower or middle level manager who was objecting rather than the senior executives of a company. And so it wasn't a problem. However, there were 213 cases at the grievance committee which were rejected. And 63 cases at the time of the report were still under examination. And the 213 case rejections were based upon financial claims against the worker, an infringement of the residency laws, and criminal charges against the worker. We have no further details of that.
Excuse me, Ray.
Yes.
When they announced the law, publicized it in November last year, December, didn't they say that there was a 72-hour turnaround?
Yes.
Because that is significant.
The grievance committee has to make a decision on a case that's brought before them within 72 hours, which means that the employee should notify the exit within 72 hours. Did you... Sorry, those who are getting translation didn't hear it. So we don't have any more precise details of the 761 cases. For example, whether they were more highly skilled or professional employees who were better informed and more able to lodge an appeal to the grievance committee. Unfortunately, employer objection cases do not go automatically to the grievance committee for explanation and adjudication. The employee must submit a grievance form to the grievance committee with supporting documents. This means that an employer's objection may go undetected if the employee is unwilling or unable to lodge a complaint with the grievance committee. If all objections to the exit were automatically referred to the grievance committee, it would remove the issue out of the private, non-transparent realm into public accountability, in my view. And I don't think this is currently the case. It may be argued that the change from an exit visa to the travel notification is quite subtle, unless more information is made available. For example, a worker who wishes to terminate the contract and leave before its expiry may be prevented from doing so, and that may well be a classification of forced labour. Also, we don't know who in the employing company makes the decision whether to accept or reject a travel notification. It may be a lower or middle level manager who in practice may extort money for approving such requests, and we know that that does occur. At one level, it's perfectly understandable that individuals should be held accountable for the breaches or potential breaches of the law, including debt and embezzlement and so on. However, it's also a means of control, and employees can be used, control over employees that can be used as a means of forced labour. Preventing a person from leaving the country is a breach of the fundamental right of freedom of movement, Article 13 in the Universal Declaration of Human Rights, and indeed an Article 27 in the Arab Charter on Human Rights. Let's come now to the wage protection system. The wage protection system, or WPS, looks to have been quite successful as an official means to monitor and ensure the timely payment of wages by mandating electronic payments into bank accounts for all employees. The non-payment and delayed payment of wages, in fact, has been the main complaint by migrant workers every year. The non-payment of employees is, of course, an issue that resonates strongly with Islamic ethical principles. The Prophet, peace be upon him, stated, for example, you should pay the labourer his wages before his sweat dries. Further, I am the adversary of 3 people on the day of requital, one who gave in my name and then was treacherous, one who enslaved a free man and consumed the price, and a man who employs a worker but does not pay him his rightful wages. Now, Qatar's wage protection system came into effect on the 3rd of November in 2015, with arrangements between the then Ministry of Labour and Social Affairs and the Qatar Central Bank. All employers were required to pay wages either monthly or fortnightly to approved banks in Qatar and in Qatari riyals. The ministry set up a special inspection unit to monitor compliance. Penalties for non-compliance included up to 6,000 riyals per violation, with visa quotas to be reduced or blocked, bans on future hiring, and possible imprisonment. Now, 3 significant benefits arise from the wage protection system. Firstly, it provides greater transparency and accountability with regard to wages. It also exposes the common practice, at least in the past, of the visa trading or free visas, where workers are not actually employed by their sponsors, and so they have to fix and regularise their situation. And thirdly, manpower or labour suppliers who do not pay workers when they are not being hired out is a common practice, and that should be picked up by the wage protection system. In the first year, 385 violations were registered against companies that failed to pay wages on time. And between January and October 2016, the number of wage complaints by workers, in fact, dropped by 30%. By February 2017, 44,245 establishments, that is 81% of companies in Qatar, had registered, and that covered around 2.094 million employees. So it is quite a comprehensive coverage at this point. Now, all employers must provide the bank with details of the basic salary, the net salary, the number of days worked, extra hours, allowances and deductions, which is called the salary information file. This essentially is a pay slip, but it's interesting that when an employee goes to the ATM or to the bank to get their money, these details are not there or provided by the bank. I see this as pretty much a pay slip, but the employer has to provide a separate pay slip to the employee so that the employee can verify that they have been paid the correct wages in relation to all the allowances and deductions and so on. But it's provided by the employer, but it goes to the bank and is not given directly to the employee. Now, one possible problem here is that there does not seem to be a means by which the government can independently determine if the basic salary which is stated on the employer's bank entry is the same as that on the contract. However, as the recently introduced electronic contract or e-contract system gathers pace, it will be possible for new entrants, that is, to be able to have an automatic electronic means to match the wage on the contract with the wage that is paid into the bank account. Now, from the 13th of December in 2016, these electronic contracts, which cannot be amended or deleted, became mandatory, but only for the newly recruited workers, and so it's still being tested. A second limitation concerns those unscrupulous employers who actually withdraw the salaries of their employees that they have deposited by using the employees' wage cards. Anecdotal evidence suggests that employers or managers convince employees that they will save them the time that it takes to wait in line at the ATM. They take the wage cards with the PIN numbers and withdraw the cash that they then give to the workers. Obviously, it's not certain if the workers are given the full amount owed or if they're charged for the service. And the wage protection system, of course, cannot reveal this kind of practice unless employees themselves make a formal complaint. The third limitation of the wage protection system concerns the actual inability of the employer to pay the wages because of their lack of financial capacity. Earlier this month, a construction contractor in Qatar, responsible for a large construction project, called a meeting of its subcontractors. The project manager of the contractor informed the subcontractors that they had not been paid anything for more than 1 year, and therefore they couldn't pay them. One of the subcontractors at the meeting was almost in tears, saying, "We have not been able to pay our workers this month and we have no more money." The main contractor denied any responsibility, saying it was not their problem because the government had not paid them. Now, the construction industry is a very vulnerable and cutthroat industry in this regard. It's highly labour intensive, it is price competitive, it is sensitive to economic swings and typically uses precarious or flexible labour arrangements that make them easily dispensable. Governments rely upon main contractors, or clients of the government, rely upon main contractors to shoulder the burden of investment, who in turn shift the responsibility of their work and employment onto others, subcontractors and labour suppliers. There can be anything between 5 and 15 tiers of subcontractors, a process that is referred to as externalisation of labour. Now, the power differentials between the state, the principal contractors and the subcontractors means that those lower down the business chain are vulnerable to exploitation also. That vulnerability is enhanced by the common but risky contractual agreement to pay when paid. Typically, clients do not pay on time, nor do main contractors, and that may indeed be a deliberate policy to reduce their financing costs by shifting the burden down the supply chain. And as the flow of cash dries up, the only option for these firms with limited cash reserves is to borrow from the bank or renege on their debt to the workers. Although there are large variations in the reliance upon subcontractors to employ workers for projects, it can range between 8 and 80%, according to a study done by the Business and Human Rights Organisation. If the state or the clients of the state do not pay or don't pay on time, unless contractors and subcontractors have sufficient financial reserves to draw upon, they may indeed ultimately close. And indeed, it's been suggested that withholding payment can be a deliberate strategy to force companies into bankruptcy, at which point they no longer have to pay at all. In turn, the bankrupt companies can default on their payments to workers, and this happens. And such events, of course, would seem to be beyond the current GCC and Qatar wage protection systems that are currently in place. All wage protection system regulations, however, do provide the penalty that non-payment of wages after 1 or 2 months allows employees to transfer to other employers without permission. But this assumes that they are able to find alternative employers and with the same or better wage conditions. Now on to the last issue. Recruitment and worker payments. As the Qatar labour law prohibits workers paying fees or costs for recruitment, it's always been, that's in the labour law, it's always been interpreted as applying only within Qatar. and after the workers' arrival. Now, for the first time, the Qatar government has acknowledged the need to be proactive in protecting workers before recruitment. To this end, the report highlights its engagement in recent regional and international meetings addressing the issue of recruitment charges to workers that create the conditions of indebted labour and forced labour. Meetings such as the Global Forum on Migration and Development, which was in Dhaka in 2016, the ILO's 16th Asia and Pacific Regional Meeting in Bali, and the Abu Dhabi Dialogue in Sri Lanka in February 2017. Now, I've published extensively on this issue and participated in those meetings that I've just mentioned, and so I won't go into a great deal of detail. I just want to pick up on some of the statements in the government's report that suggest inadequate attention to the matter. The report states that Qatar has bilateral agreements on recruitment with some 36 labour-sending countries, but there are no details regarding the nature of these agreements and whether the issue of ethical recruitment where workers do not pay is included. It only states that there are ongoing discussions that are held annually through meetings of their joint committees. The Qatar government did attempt a bilateral agreement with the government of Nepal last year, whereby it was to be agreed that Qatar would only accept workers who had not paid anything to recruitment agencies. Unfortunately, the Nepal government did not sign that through pressure from the Association of Private Recruitment Agencies in the country. Now, first, the report claims that Qatar has contracted with a company called VFS Global. It is a Swiss-based but Indian origin company that currently only specialises in visa services. It's anticipated that the VFS Global will streamline the recruitment process electronically through specialised service centres that will be set up in Bangladesh, Egypt, India, Indonesia, Nepal, Pakistan, the Philippines and Sri Lanka. And this is very similar, in fact, to the UAE's development of visa offices in many of the labour-sending countries, but where they have been established by the government rather than a private contractor. The company will be establishing a database of job seekers according to certified qualifications, occupation and experience. They will be providing the visas, they will be providing the contracts, registering the biometric data and facilitating information and appointments. All fees for the VFS Global Services will be borne by the employer. And they argued that forging and substitution of contracts will no longer be possible, as contracts will be registered and signed by the worker before departure at the service centres. And I quote also, and workers will no longer assume any fees or expenses for their recruitment from abroad. It would seem that VFS Global will act as an arm of government in processing all recruitment for Qatar. It would seem that all migrant workers coming from abroad have to be processed exclusively by VFS. This is what it looks like. However, what's not entirely clear is whether private recruitment agencies in these sending countries will no longer operate in recruiting workers for Qatar, or whether private recruitment agencies can also provide services to VFS Global. Secondly, it's also not clear how the database is going to be established and how applicants will get their names added, or indeed chosen, or whether workers will be charged a fee to be on the database. There are a lot of questions to be asked here. And what will be the role of the origin country governments in this process, particularly with regard to attestation of documents and so on and so forth. Now, until the new VFS electronic system of work visas, contracts and recruitment comes into place, the current corrupt practices are in fact continuing. And we do not know when VFS is going to be up and running on all of these issues. So I do want to impress upon you the seriousness of the current and past recruitment practice. Workers are still paying large amounts to recruitment agencies who use their money to provide fraudulent kickback payments to personnel of employing companies for the labour supply contracts. These transactions are bribery and extortion and should be viewed, in my view, as criminal acts. They amount to hundreds of millions of dollars and billions GCC-wide. We do not see moves in Qatar or elsewhere in the GCC to expose and prosecute this behaviour. But whose responsibility is it? The report argues that the corruption in recruitment begins in the labour origin countries where workers are charged and pay those fees, or the charges rather. I think this is a mistaken view. As I've noted in previous publications, it really begins in the project tendering stage in Doha and other countries of destination. In order to be more competitive, contractors assume that they do not have to pay for recruitment costs because they have unethical recruitment agencies who will charge workers to pay not only the costs but also kickback payments that can be anything from $200 to $1,500 per worker. And this assumption means that the project bid price can be minimised. Where there is a policy that the lowest bid wins the contract, companies that refuse to pay recruitment costs may be in a better position to be awarded the contract. With these practices occurring mainly with the subcontractors down the supply chain, it may be that the perpetrators are more likely to be expats than Qatari nationals. This does not mean, however, that the state and the companies themselves, which must be 51% owned by nationals, are not implicated. In a recent fatwa issued by Dr. Munza Kaf, who is a professor of Islamic Economics and Finance and Banking here at the College of Islamic Studies, has stated, as the laws, this is a fatwa, as the laws and regulations require that the employer must bear the recruitment, visa and transportation expenses and costs, all such expenses or costs, whether in the country of origin or in the country of work, are considered part of the employment contracts which are undertaken under these laws and regulations. Nationals and residents of destination countries should make adequate conditions that prevent such agencies from charging potential employees any such forbidden charges or costs. Failure of having such conditions and failure of enforcing them puts them in the square as accomplices with such agencies, making nationals and residents accountable from a Sharia point of view and should be made accountable from a legal point of view. If kickback happens from recruitment agent and visa agencies to employees of national and resident potential employers, not only is the bribe receiver accountable, but also his or her employer by reason of subordination. In such cases, employers become responsible to compensate employees for the amounts extorted from them. Corruption and kickbacks, it's concluded, are prohibited to the extent that the Prophet, peace be upon him, equates bribery giving and taking to transgressing the boundary of Islam itself. In an article by Iqbal and Lewis called The Islamic Position on Corruption, we find different models of corruption or fasad in the Quran. There is also the suht, that refers generally to the means of unlawful gains, quote, with bribery occupying a particularly offensive position. A means of earnings that destroys the Islamic way of life and erases a person's or a nation's morality and character. Such is the view of bribery. The payer of the bribe is called the Rashi, its taker, the Murtashi, and the mediator between them, the Raish. As applied to the corruption in recruitment, as I have described, we can call this market-centred corruption, which involves transactive corruption, which, I quote, is mutually arranged and agreed upon and advantageous. This is where I would say we would call this bribery. And extortive corruption, which involves some kind of compulsion, which is extortion. Now, bribery and extortion, as I've said before, are criminal acts, and they should be punished as crimes, whether in the public or the private business sectors. In recruitment corruption, there are two relationships. Firstly, the relationship between the employing company at destination and the recruitment agency in the origin country, and secondly, between the recruitment agency and the migrant worker. In the first case, if the recruitment agency offers the employing company money in kickbacks and reimbursement, it's bribery. If the employing company provides the labour supply contract to the recruitment agency on condition that the kickback payments be made, then it's extortion. In the second case, if the worker offers money to the agency, which is fairly rare, autonomously, then it's a bribe. If the recruitment agency offers the job on condition that the worker pays, then this is extortion, because it is against the law. Either way, these economic transactions are not only unethical, bribery and extortion are criminal acts. I'm labouring this point because it's actually not always seen that way. And Iqbal and Lewis argue that there is zero tolerance for bribery in Islam, and Islam rejects any idea that bribery serves as the grease that oils the economic wheels. I like that phrase. Indeed, a culture of corruption in recruitment has been operating for decades, for generations. And one may question why it has taken so long to be addressed, and why prosecutions have not been implemented. Perhaps it is because that many do not see it as corruption, but rather merely the way of doing business. The culture of employers is the expectation that they don't have to pay recruitment costs. The culture of agencies is that they expect to pay the personnel of employers to get labour supply contracts. And the culture of migrant workers is their expectation to get a job in Qatar, they have to pay. And the expectation of workers having to pay means that even if the employers do pay all the recruitment costs as required by law, the recruitment agencies can still take money from the workers for their own profit and make them promise not to tell anyone. It may be assumed and hoped that once the new recruitment arrangements are in place and workers no longer pay, the corruption will cease because the money that feeds it will no longer be available. This is something that I and many other people around the world have been advocating for many years now, and I know people in this audience are in the same position. To conclude, the Qatar government has presented a report that addresses most of the concerns of the ILO, and most are very promising reforms. But there remain a number of questions regarding the administration of these reform laws. Further, a number of the reforms still remain simply promises. For example, stopping workers paying, increased capacity of labour inspections, a new law for domestic workers, and so on. One hopes that there will be sufficient evidence of positive outcomes of these reforms by the end of this year to satisfy the ILO complaint and prevent a commission of inquiry. It will also be interesting to see how the ILO itself intends to verify the implementation of these reforms. And I think I'll leave it there. Thank you very much for your indulgence.
Thank you, Dr. Ray. Now the floor is open for question and answer. I'm not going to summarize. It's almost 1 hour for speaking about migration laws and human rights and ethics. I'm sure you are excited to learn more about many issues raised in this talk. So I would like to go for a first round, having 3 questions first. Then we'll continue like that. So Dr. Ray will receive 3 questions, respond to them, then we'll take another round and so on and so forth. So please, welcome. So please raise your hand, introduce yourself, and ask your question in a very direct and concise manner. Thank you. So over there, please go ahead.
Thank you. I have 2 questions. I'm not sure if I can ask 2 questions together.
Sure, no problem. Just go ahead.
Okay.
2 questions.
The first
yes.
one is about to change the employer, worker has to demonstrate that they have submitted the resignation to their company prior to 30 days or 60 days. So, if the employer, or what sort of document the workers should demonstrate to the committee that yes, they have resigned to the company or informed to the company at the right time, or if the employer not agree to give him the proof that he has submitted the resignation to his company. So in that kind of case, what is the alternative way to demonstrate the circumstances? This is the first question. And the second one is still linked to the change of employer. Dr. Ray has mentioned that the required document is one of the education certificate. So, in the education certificate, the Qatar government has implemented the rule that the certificate must be attested by the college first, the way the workers, he take his degree, then he has to go to university, and then Ministry of Foreign Affairs of his country, then embassy in Nepal, and again the Ministry of Foreign Affairs in Qatar. So there are so many procedures he has to follow to obtain the verification. So in that case, if workers is here and he want to change his job, so how he can get this all the procedure? This is the first. And the second, I'm from Nepal. In the concern of Nepal, like students, they can directly enroll to the university. They don't need to enroll to the college. They can register their name to direct university, and he can give the test. This is called private exam in Nepal. But the required document in Qatar is he must get the document from the college that he is the regular student, obedient student, and he has studied full time in the college. But in my case myself, I never joined any campus. I directly enroll my test to the university and I get my degree. So if, in my case, if I want to submit the education, I cannot obtain the needful documents. So these are 2 questions to Dr. Ray. Thank you very much.
Thank you. So, yes, over there, please. Please hand the microphone to him. No problem. He will pass the microphone to you. Yes, go ahead.
My question is, this requirement for a NOC if you wish to change jobs from your employer, I'm not aware of why that was originally introduced. And my guess is it was a means by the government to stop wage inflation. Would I be right in that guess?
Sorry, can you just repeat the question again? You mean under the kafala system?
Yeah,
Why?
I'm interested why this system came about.
Oh, yeah, okay.
Okay, who else wants to? Yes, it's pass the microphone. He got the microphone. Sorry, just go ahead, please.
Thank you, Victoria, for this informative session. My name is Mahmoud. I'm a human rights activist. Part of the things which have illustrated the WPS, the maybe changing response might be somehow workable. But for freedom to move, in order to leave the country, yourself or myself, I still have to go and obtain an approval from a manager, a company, organization, and then they notify Ministry of Interior. I don't have an access myself or yourself to go and notify the final decision maker to make me leave the country. I just would like to link this to the figure which you shown about the WPS. There are more than 2 million beneficiaries of that system. This means, in order to make the freedom of move an applicable scenario, that means a huge cultural change. Do you agree with me that it's a cultural change more than legislations or rules or regulatory change, and that is the responsibility of more than one organization? In this case, the responsibility was of Ministry of Labour or Ministry of Interior. That will be the responsibility of multiple organizations within the country. Thank you.
Thank you. Now we allow Dr. Ray to respond to these questions, and then we'll take another round of questions. Thank you. Please, Dr. Ray.
Thank you very much. Deepak, I am not quite sure what your question was with regard to giving 30 or 60 days notice to the employer. You're saying that if there is no evidence from the employer that that notice has been given, what does the worker do? Right? Is that the question? And I'm really not sure. I mean, if you give notice to your employer that you're intending to leave, then something should be done. If the employer, this is part of my argument, my criticism, is that if you want to leave the country, you need a notification of travel, or what was originally called the exit visa, right? So the employer must respond to that, either yes or no. If they respond yes, then they will make the provisions to allow you to leave. If they say no, however, even under the new system, nothing may come of it. If you are refused the notification to leave the country, then you can bring a case to this grievance committee and have a decision within 72 hours, right? And I believe that is possible. The question is whether you will do that, and this is why I raised that issue. Some people may simply accept the refusal and do nothing more about it and simply stay until the end of their contract, or I don't know what they're going to do, right? Or sign a new contract, or there are many different scenarios. And you're quite right with regard to the certification of documents like the education certificate and so on. This can be very problematic. Unless the worker already still has the documents that they used when they first came to the country, when they first became employed by the employer, and that they can recycle that. This I don't know, whether that is possible or not. Or whether they have to have it all redone by all the ministries and so on back in the home country. This is not clear, and it's a good question to ask whether that whether if you still have those documents here, whether you can simply use those for a new employer. But then there's the issue of the police clearance. With regard to the NOC, originally, the whole point of the kafala system of having a sponsor who has responsibility for you as an employee and also has tremendous control was that to change employers or to leave the country. I mean, there are only 2 GCC states now that still have an exit visa program, which is the Saudi Arabia and Qatar. And now Qatar is I think it's still there, but it's been changed, and it's not quite the same. But the NOC was that the employer has control to stop you, for example, from taking work with an employer who might be your competitor. Certainly it was also the case with regard to domestic workers, that a family would not want a domestic worker to be able to go and take a job in the household of a neighbour because they've been privy to the secrets of the family. And many corporations have the same idea, that they do not want employees to go to a competitor because they may be able to give them inside information of that company, trade secrets and so on and so forth. But it's also basically very much a system of control. And it has prevented the development of a labour market within the country. So there is no national labour market because people are not free to leave. And the NOC and the ability of an employer to refuse for you to leave and find work with somebody else was part of that process. As that begins to be watered down, and people at the end of their contracts can freely find work with other employers, then we will see a labour market beginning to operate, as is occurring in the UAE, for example. But that remains to be seen. I'm not sure what the question was about the exit.
Freedom of movement.
The freedom of movement and exit visa. Well, that's very much an issue, a rights issue as well. But I do see the wage protection system is a cultural change. But it strikes me as rather strange that it has taken so long to be implemented, such a process, to actually monitor and punish the violators for breaches of the law with regard to payment of wages. But that remains. Still, there are various issues in relation to that.
Thank you, Dr. Ray. We'll start the second round of questions, and we'll start with the gentleman here because he raised his hand.
Kevin's first.
No problem. It's all right. Please, go.
Hello, Ray. Thanks for your lecture. Just an update for you, live from Sowell Road, and I've experienced the ordeal of transferring employment, and now the reality is, in practice, you need 2 letters of no objection. The law says no, you need 2. You need one that's addressed specifically to the Director of Immigration, and at Sowell Road they won't accept a copy of the letter as they did before. It has to be addressed to the Director of the CID. So that's just an update for you.
Yeah.
My question relates to your opinion on the potential use of insurance to protect workers who may not be being paid, and whether it's a useful initiative that maybe even the government could get involved in, or even private insurance companies, just to cover the workers for that critical 30 to 60 days while the employer attempts to redress the situation.
Yeah. Thank you.
The gentleman over there, please. No, you first. Then.
Ray, it's a very complex issue and multi-layered and interwoven. But what comes to me, particularly in your presentation of the law and the concerns you have about the law, there are 2 interrelated issues, and I'd like to know if you've had any thoughts on how these can be addressed. The 2 issues that I see are, the one most obvious is you can have all the laws, pass all the laws in the world. Without enforcement, the laws are meaningless. They have no teeth unless they're enforced. And this has been an ongoing problem in this country for all the years that I've been here. And it remains, it seems to be a big, big problem. That's number one. The other side of that is to introduce these new laws, which are not so black and white as you clearly pointed out, that to say the kafala system is over, and yet there are shadows of it still remaining in the way the new laws have been implemented, has been very confusing for workers. I've had discussions with many workers in the last 6 months regarding their awareness of these changes and the impact of the changes. And there's so much misinformation and so much that has been misunderstood. Obviously, it's not in the employer's best interest to educate their workers that the workers have more freedom than they think they have. They want to maintain that control. But even beyond the change in the law, I know 3 people who work for security companies, and who seem to be, anecdotally I will say, the worst employee abusers in this country. They work 30 days a month and are given 1 day off. They work 12-hour shifts and another 2 or 3 hours in transportation. They triple bunk in the accommodation. And I just met another one who works for a security company who says, I only have a day off when I ask for a medical emergency. And they work 12-hour shifts. So my point is that they are flagrantly abusing the old laws of employment. And this comes back again to they're terrified to lodge a complaint because they don't even know how to do it. They don't even know that they can. And of course they're afraid that once they do that, they'll be kicked out of the country. So the question is really about what ideas do you have, or have you heard anything that can improve the implementation of enforcement, government going into companies maybe, and having programs of education for middle management, who, as you know, are the worst abusers of all in large companies. And the other side is just basic enforcement, getting people out on the job sites in the companies and asking questions and trying to find out what's really going on.
Thank you for your question and comments. Can you pass the microphone over there? And then after that, the gentleman.
Hi, my name is William Hopkirk. I come from Georgetown University, just across the way. Ray, regarding the ATM withdrawals, you mentioned the practice of the employer taking the ATM cards, confiscating them with the PIN codes, and then withdrawing the salaries out from the bank machines. We terminated a contractor this afternoon who we directly contract with, following an audit we carried out last month, where one of the many wrongdoings they were doing was this practice. And I just wanted to know, I mean, what's the main reason they do it? Because what we found out is they were paying them at the beginning of the month and then taking the money out and then giving it to them in cash 10 days later. And they seem to be giving them the correct amount. Would I be right just thinking it's a cash flow thing? Is there another scam I'm missing?
Okay, just 1 second.
He's been asking for.
No problem. Just later on. Just the other one first, and then we'll come back to you. Just be patient.
Good evening, Professor. I am Farooq from Bangladesh, Association of Recruiting Agencies, Senior Vice President. The articles have seen that you have put it over here. These are fantastic. I have started to export in my recruitment business since 80. That means 1979. The recruitment was before ethical, and it, as for in your article you have mentioned everything, now it becomes unethical. So I have few questions. How to, if Qatar is doing the similar way recruitment, if the neighboring country is not doing the similar process, I think what will be your suggestion, how you will make individual country the similar way? The second question is, nowadays the employee are coming a lot of substitute, making a lot of substitute contract. That means they change the contracts with, originally they show it in the labor sending country one, when they come they found it's different. This is also, I think you need a recommendation about this one. And third thing, before the government, receiving country of the governments, their project, they used to give ticket money on the tenders, and employees are coming without levy to pay the governments. Now, a lot of companies, and they are saying, big companies, they are saying, we have to pay the laborers coming from abroad, these third world countries, poor countries. They have to pay a lot of levies to the governments. That's why they are taking this money to pay the levies of governments. And also, because governments is now not giving any tickets to come in the employment. That means employment reaches their country. So that's why this illegal transaction is there take place. So what your recommendation to the labor receiving country? That means, in my opinion, they should not, for the poor workers, or they should not charge any levy for these workers, should come previously free without any government fees to come over here, and also tickets. They should give the tickets. And third thing, in my opinion, if the labor is a labor sending country, we need to make them educated in their awareness. What will be, they should do it. And when they come over here, what they should not do it. What will be recommendation of awareness program. The third thing, and the last, BHF is an Indian company, original though, but they are dealing with many embassies, not only for employment in Canada, Europe, and many countries. The charge they are doing and their agent is doing is very high, because their number is very big and they are doing individually. Yes. In my opinion, similar, if you are giving, or any government is giving, there should be at least 3 companies to be given to make a competitive prices, so that he can go anywhere, not individual one. It makes he makes a lot of money, because people do not have any other already to go, so everybody has to go there. So this is my idea and my question to you. Thank you.
Thank you, and we pass the microphone here, and thank you for your patience and understanding. Please.
Dr. Ray, thank you for your valuable insight. My name is Shibli Aziz. I'm the managing director of a training and recruitment firm from Bangladesh. And what I wanted to ask you about was the wage protection system. My question is, how does the wage protection system ensure that workers of different nationalities working on the same trade are being paid the same salaries? That's my question. Thank you.
Okay, so now please, Dr. Ray, go ahead. If we have time, we will take another round of questions. Yes, no.
Okay. Kevin, thanks very much. Yes, this issue is well pointed, well taken on the 2 letters of NOC. We're still learning on what's actually happening, and your insights are very, very valuable to give us what's going on. With regard to insurance, I think this is very much a way forward, and still in its infancy. But I think that the developments in Jordan, for example, an insurance company in Jordan, I think that somebody from Jordan, an agent from Jordan, is going to be here very soon this week, and we will learn more about how that's operating. For example, the insurance company will provide insurance in case a worker absconds, right? That's particularly for perhaps domestic workers, but that can be broadened, I think, for a whole range of these kinds of issues, and particularly for non-payment. And I think that what you're proposing, that if it's just for 30 or 60 days for a company to wait until it gets paid in order to be able to pay its workers and has that insurance to cover them, makes a lot of sense. I think we just have to find the insurance and its actuary to do the calculations to see if it's viable, right? So I think that may well be a way forward for a lot of circumstances to cover people here. Stan, your point about laws that have no teeth and enforcement is a big issue, but that's a big issue everywhere. I think that one of the issues that actually is raised by the report, and in fact it's a key issue in the complaint against Qatar, is the inspectorate. That is, who are supposed to be the enforcers, right? And there just hasn't been enough resources and capacity. But there is a promise there to improve it with a whole, and to do that in conjunction with the ILO. The ILO is providing technical assistance to the Qatar government, specifically on labour inspections and the inspectorate itself. So a lot of training, they need to increase the numbers and to be much more systematic and targeted in the way in which they do inspections and audits in order to ensure compliance and to punish those who are not. And this is an ongoing issue, saga in a way. And I like the way you put it, that the shadows of the kafala still remain, and I like that, and I think it's true. Now, the other thing that the government, although I didn't mention it, the other thing that the government has been doing awareness-raising seminars all around the country to explain the new laws. I went to one of them. I was not all that impressed, but there are certainly attempts to inform workers and independently. Yeah, workers were attending, but just to tell you, the session that I went to, the representative from the Ministry of Interior was there, but the representative from the Ministry of Labour, if I can shorten the name of the ministry for a second, he didn't turn up until about 5 minutes towards the end of the seminar, and so there were many unanswered questions, but that might have been an aberration. But there have been serious attempts to bring about awareness raising. To what extent that is done in terms of explaining how complaints are made, I'm really not sure, but that is a key issue that workers need to know how they can make a complaint. And there are NGOs, international NGOs, doing experiments and providing funds to see how they can provide workers, and particularly domestic workers, with mobile phones and so on and so forth, where they can gain direct access to a grievance, somebody who can help them with a grievance in one form or another. So there are lots of ideas about that. It still remains to be seen how successful they will be. William, I'm really interested in the issue of this terminated contractor for using the cards of the workers. Why do they do that? You know, if they're paying the workers what they got out, what they put in, I don't really see what it's about, unless it is a process of control or a process of manipulation. But I don't know, to be honest. Where they might be making money or doing favours or things like this, who knows what might be occurring. I think that you need probably much closer observation of what's happening and more of an ethnographic kind of approach to that to really find out why. And it's a very good question. And we should try to answer it.
Just related to a question you had later, they also discriminate against it's a Bangladeshi company and they discriminated against the employees.
Right.
So it relates to
Look, well, you know, this happens a lot where conflicts between different nationalities, inter-ethnic rivalry and conflict, that's never been clearly analysed, but we know it occurs and occurs all the time. I mean, with regard to the your question about the WPS and how that can address the issue of wage disparities, you know, the principle of equal wage for equal work, well, it doesn't. There is no minimum wage other than those minimum wages for occupations that the embassies of the different nations provide, and not all do. And we are talking here, as I mentioned before, that there is no local labour market. So if you have no local labour market, you don't have people competing with one another to provide better wages and conditions for workers as a market process of supply and demand. It is an international labour market. And so workers are being recruited from different countries, and those different countries are competing with one another because they want to maximise the number of their nationals who go abroad to work because of the remittances which they return back to the countries. And those remittances now are critical for the economies of those countries. So that's why you get these wage differences, so that you can be working alongside another worker from a different nationality, and they may be getting more or less than what you get. That's because they're recruited in a different market, right? So they're in a bilateral arrangement between the recruiters and the employing companies, and they may pay different wages for people of different nationalities. Okay, so and the wage protection system has no way of interfering with that. There's no mechanism to interfere with that. It's just a monitoring mechanism. And so far, what I can see is that it really only monitors whether a person is paid and when they're paid, or whether they're paid on time. Okay. To our colleague at the back there, with regard to, I wasn't quite sure on all of your questions, but one of the issues seems to me that you raised was the idea of the level playing field. That when you are introducing or wanting to introduce ethical recruitment, if you are an ethical recruiter, as there are some people in this room, then you are competing with others who are unethical. And those who are unethical are going to get money from workers, and it's very, very difficult then to compete against unethical agencies. That's part of the problem. And the issue of VSF being a monopoly is indeed a very, very good point. We don't know yet, it seems to me, we don't have enough information yet on that company or on the contract that it has with the government on how this is going to operate. But it would be rather surprising if they did have a monopoly over this and how it's going to work. And yes, substitute contracts are rife in many places. The government is assuring us that the new reform is going to stop that with these offices that the company is going to establish abroad, just like the UAE put in a very good system to make sure that even a letter of a job offer is counted and registered as a contract, and the worker should actually sign that to make sure that there's no contract substitution on arrival in the country of destination. So, yeah, I think I've covered most of that.
Okay, ladies and gentlemen, we are approaching the end of this session, but we will still allow a couple of questions, no more than 3 questions, I'm sorry. Only burning questions we can accept, we can accommodate. So we'll take, let me just find the question and then you can start talking. I have a question here, there and there. That's the 3 questions that I have. I hope that you are all happy. So please, we'll start from this side. Please go ahead. All right, if you have the microphone, you can just...
I'm happy to shout. So I can use
No, the interpreters need the...
I'm a sponsor and an employer, and I've heard some discussions about the importance of law reform. Professor Ray, my experience in Qatar right now is that the reforms which have taken place allow companies such as mine to actually embrace change. So I'm committed, using an app on my phone, to grant my employees effectively infinite exit visas. And I do. So all of my employees can enter and leave Qatar whenever they wish. All I ask is that they let me know in advance. So in response to the point about law reform, actually there's a platform now for cultural reform, and my company embraces that, and we're proud of that. So my question to you, Professor Ray, is do you think that's a fair observation of the reforms and the platform for change which has occurred? And secondly, which isn't a question, thank you for mentioning not being paid. We don't get paid. I pay my staff. Soon, I won't be able to pay my staff because there's a shortage of money in the economy in Qatar. I'd like your comments on that.
Thank you very much for your comprehensive input. Just I would like to know that while you mentioned that every employee can perform 10 hours daily, whereas if willingly you want to continue more than 10 hours, is allowed or not? Number 2, you have mentioned that after completion of 5 years contract, he is allowed to take other employment, but it is not necessary that all the employees are having 5 years contract. Some are 1 year, some are 2 years. So what about those who have completed 1 year and 2 years? Automatically, any time after completion of this contract, they can move to other sponsor or not? Thank you.
Yes, gentlemen.
Thank you. First of all, Professor was very nice lecturing. And if you allow me, I will make some considerations and then in the end I will finish with the questions. I'm a short experience in construction. I just arrived in Qatar in 2013. And now we know that around 60% of the population are living in labor camps. Now they call it welfare facilities or workers' accommodation. So I will focus my questions on this particular problem. When I start to do inspections, I'm working in the fire safety in one of the largest projects in Qatar, which is the Lusail City project. So within this project, we have now more or less 50,000 workers on a daily basis, not counting the different shifts. I'm working seconded for the client, so we are overview most of the contractors. And it's very hard because we have due diligence to the main contractors, which is, for example, they have 18 labor camps, but we cannot control all the rest of subcontractors. So we know that QF standards were very good. Now we have the Supreme Council
also, but the implementation of all these standards are very, very, very hard. So I think all the problems are already identified. And we know that highlights are on the stadiums. Stadiums is just a portion of the projects, the large projects are being conducted in Qatar. Just to give an idea, in Lusail we have 90 construction packages, and then we have more than 150 private developers. And this is the main issue, because the private developers, you buy your own plot, you bring your own contractor, and it's a war zone, more or less. So when we visit these labor camps, I remember 3 or 4 years ago when I visited the first one, I was in charge of the fire safety. And suddenly I stopped my inspection and I wrote one word on the report. And 2 weeks after I was called by the director, why I wrote demolished. And it was hard to explain. Even we are not talking about animal welfare, we are talking about workers' welfare, which is very, very serious. The other thing is most of the camps are illegal. They don't have registered municipalities. They don't have civil defense approvals. They don't have so on. So you can enumerate. It's really, really, most of the contractors, they have a land agreement with the landlord. They build their own camp and that's it. And they are far away from Doha. When you need to visit these camps, you need to spend 2 to 3 hours to reach the camp, to do the inspection and come back. So it's 1 day of work gone. So sometimes people are not really, really easy to do this. So once that all these problems, and it's just a minimum reference that we are doing, I will suggest some of the solutions that I want you to think that if you'll be considered or if they deserve to be considered. So I think Qatar doesn't need international amnesty, doesn't need ILO. They can be proactive instead of hyper-reactive. This is the number one. Creation of governmental welfare facilities. We have now one labor city, but we are only able to accommodate 60,000 workers. If all the labor camps belongs to the government have 100% of the control of these labor camps, it's easy to implement whatever you want. It's easy to control all the decent conditions and all the decent medical conditions that you mentioned on one of your slides. And of course, you can make money also renting this to the contractors. And this money can be used to the improvements and the continuous improvements of the conditions. Raise the levels of requirements instead of follow the minimums. This is a normal thing that we have. Why not use the biggest contractors as an example? We know that there's a lot of powerful companies in the country. This should be the example that can be used to the government to create this awareness and the conscience in all the others. Use this as the best practices and give some awards, for example, and also ban the ones that have the bad practice. Because if you don't ban, the problem will continue. Finally, induction to all workers on migrant labor laws, rights, etc. It's very hard. It's 60% of the population, but you have to spend at least 1 day in medical conditions, 1 day in safety inductions, why not 1 in their own rights inductions? So this is very important, and everybody would start to work with complete awareness about the situation. Thank you.
Thank you very much for your intervention and the questions. Before giving the opportunity to Dr. Ray to respond to the questions, can I kindly remind all the attendees here to fill in the evaluation form, and then don't forget that we have some refreshments afterwards. So, Dr. Ray, please. Thank you.
Thank you. Arnold, I really liked your intervention in the sense that you're somebody who is prepared to act ethically. The problem is that not everybody is like that. I think that what you're talking about is the potential that is there with a cultural change, with a change of attitude. Unfortunately, that's going to take a lot, I think. As you know the industry better than I do, I don't think that's going to happen overnight. But I think that it is a possibility to bring more and more people and more corporations into the fold if they are told. And I think that there are probably various strategies that need to be used. There's no one strategy to use, but rather to understand those companies that are not going to comply, and to understand and try to work out how to get them to comply and to work decently, right? And that's, I think, the challenge. And that requires a lot of thinking, a lot of planning, and a lot of strategizing. That I don't think the government has those sorts of resources at this time. I think it has too many other things that it's trying to deal with. With regard to the shortage of money, I can't answer that. I mean, that's not a field that I really know enough about. But this is a major issue, because if you have a wage protection system that's simply going to fail because companies simply cannot pay their workforce because the client of the state hasn't paid their contractor, or the state hasn't paid the client, you have a major problem. And this is where inquiries need to immediately take place when workers are not being paid, to find out why, right? Particularly en masse. And we know why. We saw the strikes and the riots in Saudi Arabia, in Dubai. It's happened also, where it finally dawns on you that it's the companies that haven't been paid. And, you know. With regard to the hours of work, yes, people can work more than 10 hours, I assume. I was, I think, referring to domestic workers in particular when I mentioned those hours of work. But that means that if people are working more than the minimum hours allowed, more than the maximum hours allowed, that's for the basic salary. So they can work overtime, right? As long as it's voluntary. Okay, rather than forced. And yes, if an employee has a contract for 1 year, at the end of that 1 year period, they can change employers. That's the law. That's the new law. What I mentioned before was if the contract does not have a fixed number of years, that is, it says on the contract an indeterminate period, which is my contract actually, it says indeterminate period, then the government translates that as to a minimum of 5 years before you can apply to transfer without permission from your employer. Okay? I don't know really how to respond to your issues about the labour camps. It all rang true. And the solutions, I'm not sure. In fact, what we could do is we could have a little chat afterwards, because we have, sitting in the front row here, some colleagues of mine who are actually involved in the construction of worker accommodation that is going to comply with the Qatar Foundation migrant worker welfare standards.
Government owned.
And government owned.
Right. Can I add one thing that probably no one...
You need to get a microphone, because the are they still with us? Oh yes, they are. Soldiering on up there.
It's a very important piece that...
Okay, well, come here. Use this.
Sometime within the last 6 months, the Emir issued a decree which states that all non-compliant labor accommodation facilities in the country must be demolished by the end of 2018. And that's exactly what the kinds of places you're referring to and you've seen, those are the target. But the other side of that coin is that employees after that date must be housed in compliant accommodation. Currently, there are only 2 projects which are compliant, Tigger City and Baraha, and even they are not compliant, but they're the closest thing to compliant. But what Ray was referring to is that we are in the process of building part of a government program to build in the next 2 or 3 years accommodation for about 100,000. We are going to be building about 40% of that. And there's a further program for another 75 or 80,000 coming towards the end of this year. So there is a movement, there is something, there is hope. The problems of non-compliant facilities and that are illegal, that are non-compliant, particularly with regards to fire safety, are serious, serious problems. But there's hope, and they are, some of these will be addressed. It's not going to be universal, but what we feel is that that government program is going to change the face of worker accommodation permanently in the future. It'll take 5 years or more for it to happen, but all that I try to find the right word to describe how horrific some of those accommodation facilities are, that they will be a part of Qatar's history.
When you mention we, is the MOL?
Pardon?
Is the Minister of Labour? Or?
It's NME.
Okay. Thank you.
That's it.
Okay.
I have nothing more to say. Thank you very much, Stan. That was very
he surprised me, you know. I was telling him just we want to conclude, and he said, that's it. So, yes, with this, really, you know, it's with a great pleasure that I announce the end of this discussion. I'm sure you can continue the conversation with the Professor Ray. I'm sure you know his email. He's around here. You can still also communicate the center. And of course, I'm very hopeful that we will still see you in future activities with us, with the Research Center for Islamic Legislation and Ethics. And of course, I appreciate your time and commitment to be here tonight instead of being somewhere else. You could be in any place, like you're at home, watching TV with the family, but you prefer to be here with us, so that's great. I really appreciate that. And that's fantastic. It was a wonderful discussion. Thank you very much. You are now welcome to join us to the refreshment, and please hand over the evaluation form, which is in Arabic and English. You can see one of the page is Arabic and the other, the back is English, so please fill in the form and you are welcome. Thank you very much.